Sprinting to the future of law. Heaven, help us. Global connectivity through space internet. Part 4. Legal and regulatory issues.
In the previous part of this issue, we reviewed several applications of space internet that are not easily viable with terrestrial wired and wireless internet services. Now let's look at various legal and regulatory considerations involved in space internet.
Licenses and authorization. Every space internet system provides internet coverage that spans across many nations. A huge challenge is the varying regulatory approaches of nations in dealing with internet access for their citizens. There is a need for international coordination to avoid conflicts among the differing regulations. In India, some of the regulatory requirements include obtaining authorization to own and operate an Indian registered satellite system, including for the Spacecraft Control Center, authorization to operate ground station in accordance with radio regulations published by the International Telecommunications Union, and a license to provide services from the satellite system. Spectrum allocation. Space internet operates on a limited radio frequency that is suitable for space to ground communication. Allocating and managing the radio frequency spectrum for satellite communication is critical as the demand is increasing rapidly. Space internet providers have to seek and obtain necessary licenses and authorization from relevant regulatory bodies in every nation in which they want to provide services. Coordinating and allocating these frequencies fairly and efficiently among multiple providers, while also considering terrestrial users, require a robust regulatory framework. The International Telecommunication Union, or ITU, plays a crucial role in this process, especially coordinating the use of frequency bands across nations to prevent interferences among satellite systems and ensure efficient spectrum utilization. Data protection. Space internet providers would need to ensure compliance with the applicable data protection laws, specifically about the collection, storage, processing, and transfer of user data. Operating in multiple jurisdictions and legal systems, managing data sovereignty issues is critical for the providers. For India, if a provider processes personal data of a user, it would have to mandatorily seek the consent of the user, disclose the purpose behind data collection and processing, and set up a procedure to seek grievance redressal for the user. Liability and insurance. Determining liability in the event of satellite collisions, service interruptions, or other incidents is a complex legal issue. International treaties are needed for liability standards. Space internet providers and satellite operators may also need to secure insurance coverage. Intellectual property rights. Space internet systems and satellite technologies in general involve significant level of IP. IP protections are typically provided within a jurisdiction with some reciprocity to other jurisdictions. However, due to the extraterritorial nature of these technologies, space internet companies may face legal challenges related to patents, trade secrets, and other intellectual property rights.
The Outer Space Treaty of 1967 establishes broad principles for space activities by nations, but specific regulations for space internet are lacking. Which national laws will apply to satellites and their operations, and how to handle issues like data privacy and cybersecurity across several sovereign boundaries remain unresolved. This is further complicated by the increasing involvement of private companies. In the next part, we will go deeper and discuss even more complex national security and environmental concerns.